Let us start. First of all, we read this quotation. समस्याएं हमारे जीवन में बिना किसी वजह के नहीं आती। समस्याएं हमारे जीवन में बिना किसी वजह के नहीं आती। उनका आना एक इशारा है कि हमें अपने जीवन में कुछ बदलना है। It means problem comes in our lives to indicate, to change ourselves according to the condition. It is just an indication to change ourselves. Let us start question number first. Question number first. Which of the following statement is not correct regarding admission under the section 7 of Indian Evidence Act? The question is, which of the following statement is not correct? Not correct. It means the statement is false regarding admission under the section 17. Okay. Read. Admission operates as waiver of proof. True. Admission is a statement which is necessarily against one's own interest. Necessarily one's against interest. Yes, it is against interest, but always not against one's interest. Under section 21 of Indian Evidence Act, there are 3 conditions have been propounded. Under these conditions, person making admission can prove such admission in his interest. So, necessarily the word, the term shows that this statement is false. So, option B of the question first shall be true. Option B is true. Okay. Next question. Question number 2. Admissions bind the maker. It means the person making admission is bound. In so far as it relates to facts, because admission is always made relating to fact, not law. If you study section 17 carefully, any fact, it means in admission a person admitted facts, not law. So option A shall be true of the question second. It means second question, option of the second question is A. This is correct answer. Okay, next. Question number 3. Under the provisions of the Indian Evidence Act. It means according to the provisions of Indian Evidence Act. Whatever the provisions are mentioned or said in Indian Evidence Act, under these provisions, under the provisions of Indian Evidence Act, admissions and confessions have the same meaning. According to Stephen, in some extent both are same. In some extent, but they are not coincidence. In some extent they are same. So admission and confession are not truly same, have same meaning. There is a difference. Admission is defined in section 17, whereas confession is defined by Lord Atkin in the case Pakla Narayan Swami versus Emperor 1939. The person making confession admits his offense expressly. So, there is a difference between admission and confession. Let us read. The option B shall be the correct answer of the question 3rd. Question number 3rd, option B shall be the correct answer. Okay. Next, who can make an admission under the Indian Evidence Act 1872? The person who can make admission, who is entitled. I have told you, or you can say, when you study section 17, section 17 defines the term admission and also mention that who can make admission. Persons making admission. Person making admission. Person making admission that person, if come under the from section 18 to 20, it means from the section 18 to 20, any person if come under the sections, it means from the section 18 to 20, only those person can make confession who are under from section 18 to 20. And circumstances are also mentioned in these sections. Such person can make confession. So, question number 4, the answer of the question, first of all, there are 4 options. person from whom interest is derived. Person from whom interest is derived. These persons are also entitled to make admission or to make admission. It is propounded in the section 18. Section 18 says that person, it means party to the suit. Parties are their representative can make confession. Likewise, parties and their representative are entitled to make confession. Likewise, other persons are also entitled to make a confession. For example, in section 18, other persons are agent and the person from whom interest is derived. These persons are also entitled to make a confession. These persons are mentioned in the section 18 of Indian Evidence Act. So according to section 18, such person also entitled to make a confession under section 18. So the first option shall be correct answer of the question. Okay. Next question, question number 5. Admissions made by a party. Admissions made by a party are evidence against. Here it is said that who is entitled to make a admission, to make an admission. Such person is also entitled to make a admission, to make an admission who is relating to the estate property. Who is relating to the estate? Estate means property. Here the option is A, privilege in estate, relating to estate. So the correct answer of the question 5 shall be A. A is the correct answer. A is the correct answer. Next question, question number 6. Which one of the following statements is correct? Which one of the following statements is correct? Study. An admission by a guardian ad item against minor is evidence? No. Admission on a point of law made by pleader in court on behalf of the client is evidence? Yes. It means if pleader, first of all, we want to read all the options, then admission on a point of law, made by a pleader, yes, in court on behalf of client is evidence. Next one, admission by one of the several defendants in a suit against another defendant is evidence. Next, admission admission of fact made by a pleader in the court on in the court on behalf of his client is evidence. It means admission on a point of law, made by a pleader in the court on behalf of the client. It means if any statement is given relating to law on behalf of client by the advocate, by the pleader, whatever law is, whatever point, whatever statement is given by the pleader, is it an evidence? It means if pleader explain the law, whether it is an evidence. Undoubtedly, the pleader explains the law, but such explanation, such interpretation is relating to the fact. So here the admission of fact made by a pleader in court, such admission, because admission is always relating to fact. Okay, admission is always relating to the fact. So if any admission is made, then if such admission is produced by the pleader of the client, such admission shall be known as an evidence. So the option 4 is correct answer. Okay, correct answer. Next question, question number 7. Statements made by an agent to any party of the proceeding are admissions in all circumstances if the court regards under the circumstances of the case that an agent is expressly authorized by the principal to make them. Expressly authorized, not only expressly authorized, if the agent is impliedly also authorized by the court, because the court thinks that he was authorized by his principal, then his statement shall be accepted as an evidence according to section 18 of the Act. So here the correct answer, if the court regards under the circumstances of the case that the agent is expressly or impliedly, both are mentioned, expressly or impliedly, authorized to make them, So the correct answer shall be C. Section 7, correct answer shall be C. Okay. Next question 8. Which out of 4 statements is true? Out of 4 statements is true. Admission is a statement made by only parties to the proceeding. Only parties. The term only is not proper. Yes, it is true. Admission can be made. Admission can be made by parties. It is true. But only parties? It is not true. Admission is a statement made by only accused. Here also only is not correct. Admission is a statement made by only any party of civil proceedings. Any party of civil proceedings. Admission is a statement that made by persons whose position must be proved as against party. As against party. Here it is mentioned in the section 19 of Indian Evidence Act. It means A is not correct, B is also, C is also not correct. D is the best answer of the question 8. Because according to section 19, admission is a statement that made by a person whose position must be proved as against party to suit, shall be relevant, shall be correct. This option is the correct answer of the question 8. This is the correct answer. Next, question number 9. Admission may be proved against the person who makes them. This rule is contained in the section. Admission may be proved against the person. It is a general statement. It is generally said that if a person makes an admission, such admission shall be against the person making the admission. Yes, it is true, but it is a general statement because under section 21 there are 3 conditions are provided. Under these conditions, a person making admission can prove such admission in the interest of himself. Okay, so this general statement is made in the section 21, para 1st. The general statement is made, and after that there are 3 conditions are mentioned under which a person making the admission can prove in his interest. Okay, so the correct answer of question 9 shall be C. This is the correct answer. Question number 10. Question number 10. Which provision of the Indian Evidence Act lays down the rule that in certain circumstances admission can be proved by or on behalf of the person making it. This is mentioned in section 21. I have told in previous question. Just like this question, it means question number 10, correct answer section 21, option D. Next question, the question between A and B is whether a certain deed is or not forged. It means a certain deed is forged or not. This is a question. This is a question. A affirms that it is genuine. B that it is forged. It means B says that the deed is forged and A says that it is genuine. Okay? It is genuine. A says that. Then which option shall be correct? So let us read. A may prove a statement by B. By B. By B. A may prove a statement by B. What statement of B? That the deed is genuine if any point, any clue is found in the statement of B. What? That the deed is genuine. Then A can prove the deed is genuine and B may prove a statement by A when if any point, any clue is found in the statement of A that the deed is forged. Both are against each other. So, the option of the question, option A is the correct answer of the question 11. It means according to the clue, according to the clue or any point that is mentioned, that is described, if found in B, A can prove the deed is genuine, and if any statement, any point, any clue is found in the statement of A, then B can prove that the deed is forged. So the correct answer of question 11 shall be A. Next question. A is accused of receiving stolen goods. It means A is accused of receiving stolen goods. It is said, while knowing them to be stolen, he offers to prove that he refused to sell them below their value. Actually, it is relating to the section 21 clause B. Clause B. The statement or admission making the person who is the maker of any admission under section 21 clause B. Those are proviso A, B, C, first, second, third, can prove such admission in his interest. So, according to the section 21 subclause B, conduct, it represents the conduct, and under it the person making such admission can prove such admission in his interest. So there are options. What? Not prove this statement. Wrong. Totally wrong. Prove it is relevant otherwise than admission. Otherwise than admission. It is mentioned in clause 3rd of section 21. 21 clause 3rd. Or you can say C. Next, prove it as it is explanatory of conduct, influenced by facts in issue. This is correct answer. Option C is the correct answer of question number 12. So this is the correct answer. Question number 13. When oral admission as to content of document are relevant. When oral admission as to content of document are relevant. When it shall be relevant. The party proposing to prove them shows that he is entitled to give secondary evidence of the content of such document. When oral admission as to content of document are relevant, it means when oral admission is relevant regarding to the document, content of document. According to section 22, if any content of the document is to be proved, oral admission should not be given. Or you can say briefly, content of document cannot be proved by oral admission. Why? Content of document must be proved by documentary evidences, not oral. But if secondary evidence are given, it means if the circumstances are available under section 65, where the secondary evidence is to be given, is to be produced before the court. Terms and conditions are mentioned in section 65 of Indian Evidence Act. If any condition is available, then secondary evidence is produced before the court. If any condition is present, in this case, then oral evidence, that is secondary evidence, shall be produced. So, the correct answer of the question A. Yes, study it. the party proposing to prove them. It means the party who desire to prove them shows that he is entitled to give secondary evidence. It means conditions of section 65 are available. When any condition of section 65 of Indian Evidence Act is available, is present, then secondary evidence shall be produced before the court. And oral evidence is secondary evidence. So, oral evidence can be produced. Oral evidence can be produced. So, correct answer shall be A of the question. Next question, question number 14. Which section of Indian Evidence Act has been amended in 2000? Which section? Section 22A. Electronic document is also included. So, the correct answer shall be A of the question. Next question, question number 15. Which of the following section of the Indian Evidence Act does not deal with the criminal matters? Which section does not deal criminal matters? Section 23 says that in civil cases, if any admission is given on the basis that it cannot be produced as an evidence, then such admission shall not be produced as an evidence afterwards. It is mentioned in section 23 and it is relating to the civil case only. So, the correct answer of question 15 shall be A. Shall be A. This is the correct answer. Next question, question number 16. Question number 16. Which section of the Indian Evidence Act deals only with civil matters? It is clearly, I have told in previous question, answer D of the question shall be correct. Option D shall be correct answer of the question, question number 16. Question number 17. Let us start. When a person makes an admission upon a condition that evidence of it shall not the given, evidence of it shall not given, the term shall not be used, shall not given, it cannot be proved against him. So when a person makes an admission upon a condition that evidence of it, it means if any evidence, if any admission of it, here the term it means admission. If any evidence of admission shall not be given, it cannot be proved against him. It cannot be proved against him. It is mentioned in the section 21. in the section 21, because any admission, first of all, read carefully. When a person makes an admission upon a condition that evidence of it means admission, shall not given, it cannot be proved against him. Okay, this is laid down in section 23, not 21, 23. If in civil case particular it is said relating to the matters relating to the civil case, matters relating to the civil case, if any admission is made upon a condition that it cannot be produced, as an evidence, then the statement cannot be produced as an evidence. So option C shall be the correct answer. Option C shall be the correct answer. Okay. Question number 18. Communication made without prejudice are protected. Without prejudice. Without prejudice. Section 23. Without prejudice, the term is used in the section 23. So the correct answer of the question shall be C. Question number 19. From the following, which is an exception to the section 23 of Indian Evidence Act? From the following, which is an exception to the section 23? Here, section 23, if any admission is given upon such a condition that such admission should not be produced as an evidence, but under section 126 it is said that it can be produced as an evidence. They are not bound. So section 126 is the exception of section 23. Here the correct answer shall be 162, 126. A. A is the correct answer of the question number 19. Okay. Next question. Nothing in section 23 of the Indian Evidence Act 1872 shall be taken to exempt any barrister, pleader, attorney, vakil from giving evidence of any matter of which he may be compelled to give evidence, and provided by the Indian Evidence Act. It is propounded in the section 126. The statement is written. So the correct answer of the question 20 is option D. D is the correct answer. D is the correct answer. So I have solved the question. That's all. Okay, thank you. That's all.